Buongiorno. Welcome to the third day of a conference on the legal aspects of a judgment of the Italian Constitutional Court, Sentenza 238, on the tension between state immunity on the one hand and reparations for victims of crimes of World War II in Italy on the other hand. This is the third day of an academic conference which took place for the last 2 days. We will now hear the results of our academic discussions. And we have invited stakeholders from the courts, from the administrations of both countries, and from civil society to participate in this third open day. This day will be live streamed by the Verfassungsblog, which is a German-based blog on constitutional law. So the whole day will be recorded. I hope that this will stimulate the discussion. The conference is organized by the Max Planck Institute for Comparative Public Law and International Law. I'm one of the directors of the institute. It is co-organized by l'Istituto delle Ricerche sulla Pubblica Amministrazione and by Vigoni. And I would now like to give the word to the two presidents of Vigoni. Ambassador Gerz.
Vielen Dank. Als deutscher Präsident, meine Damen und Herren der Vigoni, darf ich sehr herzlich begrüßen heute Morgen zu dieser außergewöhnlich wichtigen Konferenz. Vigoni ist einzigartig insofern, als es sonst keine andere Kombination gibt, wo zwei Staaten, Deutschland und Italien, gemeinsam ein Institut unterhalten und tragen, auf dem deutsch-italienische und europäische Fragen diskutiert werden. Und insofern ist Vigoni die absolut richtige Plattform für diese Konferenz und für das Thema der Staatenimmunität, die Deutschland und Italien insbesondere betreffen. Wir sind ein Exzellenzzentrum für europäische Fragen und ich würde mir wünschen, dass in dem Geiste dieser deutsch-italienischen Freundschaft, in der dieses Institut besteht, Vigoni, und in unserem europäischen Geist der Zusammenarbeit wir eine gute Lösung und eine gute Zukunft auch für dieses Problem, das Deutschland und Italien gemeinsam meistern müssen, der Staatenimmunität finden werden. Ich wünsche noch viel Erfolg für den heutigen Tag, den letzten Tag Ihrer Konferenz. Danke.
Zuerst herzlich willkommen zu unseren deutschen Freunden. Buongiorno a tutti. It is a particular pleasure to welcome you all to this important meeting. We have an experience in Vigoni to promote substantial and sometimes very engaging discussions. And I think that the work that has been done yesterday and the day before yesterday and the work that we will do together today is a proof of how lively this institution is and how we can set together, German friends, Italian friends, an example of our capacity, of our ability to tackle also delicate aspects, sometimes painful aspects, in a very cooperative spirit. And I think that in these days in Europe, like my friend Ambassador Gerz just said, this can set a very good example of how this kind of divergent opinions sometimes, or this kind of differences, which sometimes are the richness of our collaboration, can be handled in a very positive and constructive way. So thank you very much for being here, and I wish you all a good and productive working day. Thank you.
Buongiorno, guten Tag and welcome, also on behalf of my esteemed colleague Daniel Taido. Just one small correction, the conference starts right now because, as you know, everything that isn't in the media just hasn't happened. And sometimes a legal case needs publicity to have success. Nevertheless, we've been witnessing in the last 2 days, two traumatized nations lying on the couch of good old Dr. Freud, thinking they are not reliable partners anymore. So we have to look back in the past and find solutions for the future, knowing, of course, that, for example, total justice only exists in heaven. Now, this place is heaven, but we don't know who owns it in the future. And with these words, I give the floor to Professor Christian Tomuschat for a keynote remark.
Thank you, Chairman. Ladies and gentlemen, cari amici e colleghi, it is a great pleasure and honor to be here to give a keynote speech. I'm not in an enviable position. We have been discussing for 2 days, and almost everything has been said already. My task was not to give a summary of our discussions, but to present my own views, and it would have been impossible to provide a summary because views are so variegated and interesting, which could not be summarized in a few words. My notes had been prepared beforehand, and I apologize with the interpreters because I do not follow exactly the manuscript because I have learned a little bit from the discussion, which should be normal. The question now is how much should be changed from the original substance of my presentation. And I asked myself, am I the best person for that job? And probably not, because I have written some articles on the problem of state immunity, first of all. The first one in French, by the way. Then I was called to represent Germany as agent in the proceedings before the International Court of Justice. We have people who have witnessed that event. And then I wrote a short article on the judgment of the Constitutional Court shortly after that Sentenza had been issued. And in that article, I wrote that the judgment had sent shock waves through the international legal community, something that was taken up yesterday in the discussion. Now, I shall be as neutral and objective as possible, to the best of my abilities. And nonetheless, I have to present my own views, my views. These are personal views. Now, a very short introductory observation. Battles of the past should not be continued endlessly. Unfortunately, the present dispute between Germany and Italy has all the ingredients of an interminable confrontation where positions of principle clash with no end in sight. But, maybe this conference will be a step forward. I note from the very outset that this conference has not brought about the great consensus solution possibly hoped for by the organizers. This has not happened. And let me first make a general clarification at the very outset. Not being a specialist of Italian constitutional law, which is evident, it is not my intention to engage in a discussion about the way in which the Constitutional Court managed to deal in its examination of the constitutionality of the relevant norms to assess the customary rule of jurisdictional immunity under international law. Generally, such review is designed to scrutinize the constitutionality of parliamentary statutes of national origin with the Constitution, Article 134. I confine myself to noting that the Constitutional Court has refrained from declaring unconstitutional Article 10 of the Constitution, which would have been a possibility, the door opener for the general rules of international law. Now, there is, to me, a surprise finding at the very outset, silence on the main issues. The very heart of the dispute was the enforceability of reparation claims against Germany, that's evident, that allegedly have arisen for individual victims of measures taken by the Nazi authorities, the German Wehrmacht in particular, in violation of international humanitarian law. But nowhere was the question raised or answered by the Constitutional Court whether such entitlements could have arisen as a consequence of German governmental wrongdoing. It stands to reason that the ICJ was not seized with the issue. The only charge brought by Germany consisted of the allegation that Italy had infringed its sovereign right of jurisdictional immunity. Accordingly, the ICJ could not go into an issue pertaining to the merits of the cases pending before the Italian courts and tribunals. The Constitutional Court, on the other hand, by insisting on the imperative requirement that a legal right must be enforceable, would have been obligated, in my view, to state in unambiguous terms that such individual entitlements to reparation had to be recognized in law. Yet it has failed to raise the issue, which is a fairly complex one, since the doctrine of individual human rights is a post-World War II invention. On the other hand, the doctrine of contro limiti cannot bring into being a right against a foreign state. Now, second finding, the Constitutional Court has failed to mention that those who chose to sue Germany before Italian courts and tribunals had an actual opportunity to bring their claims before the German judicial system. Some of them did indeed pursue that course, rising up to the level of the German Constitutional Court. This was mentioned yesterday rightly. Eventually, all those claims were dismissed as unfounded as to their merits. Thus, remedies were in fact made available. There was a clear contradiction in the debate between, on the one hand, Sabino Cassese, who said, a remedy is a remedy and not more, that may be successful or fail, whereas Riccardo Pavone, he said, an effective remedy must have some positive result, a clear divergence between different viewpoints. In my view, it's an intellectual mistake to confound the availability of a remedy with its well-foundedness. These are two different aspects which have to be separated. Lastly, as far as the substantive aspects of the complex legal configuration are concerned, the Constitutional Court has not seen it opportune to mention that the case before it was part of a complex puzzle, the settlement of all the substantive consequences entailed by World War II in the absence of a legal instrument in respect of Germany explicitly called peace treaty. To me, this is the main lacuna also of the discussion that we have had for 2 days. Almost nothing was said about the role of Italy in World War II as an actor and not only as a victim. I think it's a poorly motivated judgment, my next section. The judgment of the Constitutional Court stands out as unique in the history of international law. I insist on that. There have been other judgments of the ICJ that were ignored by the losing party. The refusal of the American authorities to obey the injunctions of the ICJ in the Lagrand case is fresh, in particular, in German international lawyers' minds. But all those cases, additional cases that were mentioned, they were of an incidental character, centering on individual cases, but never before has a domestic court, by refusing to follow a pronouncement of the ICJ, challenged a generally recognized rule of customary law. This is new and this is unique. This amounts indeed to a challenge to the international legal order that transcends widely the underlying controversy between Italy and Germany. Its consequences are unfathomable. The Constitutional Court has carefully avoided to criticize the ICJ by pointing to alleged errors or other imperfections of its reasoning. Only the Tribunale di Piacenza ventured to take that course by holding without hesitation that the ICJ had not fully understood what stage the development of international law had reached in our contemporary world. It invented indeed a class of norms of super primacy, protecting human life and human dignity. Yet, notwithstanding the politeness of the holdings of the Constitutional Court, they certainly contain a strong implicit element of criticism, as noted, for instance, by Riccardo Pisilo-Mazzeschi. Formally, no reproach can be made to the Constitutional Court. It has acted consistently within the framework of dualism, chosen as its point of departure, confining itself to pronouncing on the effect of the immunity rule within the internal domestic order of Italy. Both Heinrich Triepel and Dionisio Ancelotti would have been happy with that methodological approach. However, some gaps in the CC's reasoning cannot go unnoticed. I mentioned the judgment of the European Court of Human Rights in Jones versus UK, which had been handed down a few months earlier. Shouldn't that have been mentioned? Because the European Court in Strasbourg embodies the European voice of human rights and would certainly have deserved being taken into account by the Constitutional Court. Even for a Constitutional Court, it is hard to argue that its national standard concerning legal remedies is higher and more demanding in terms of jus cogens than what at world level and at the European level is considered to be in full harmony with the rule of law. Of course, this is first of all an issue of Italian public law. For the Italian legal order, the Constitutional Court has papal authority or quasi-papal authority. And additionally, let me just mention some inconsistencies within the Italian practice. I mentioned first the Markovic judgment, where the Corte di Cassazione dismissed an application for reparation of damages caused by an aerial attack on civilians, alleged war crime on civilians on the soil of the former Yugoslavia during the so-called Kosovo War, allegedly with the complicity of Italy as a NATO member. The court held that it was not the function of the judiciary to protect individuals from acts of aerial warfare, since such acts were the expression of a political function. Period. Very simple reasoning. Furthermore, attention is deserved by the 2008 Treaty on Friendship, Partnership and Cooperation between Italy and Libya, whose Section 2, under the title Closure of the Chapter of the Past and of the Pending Disputes, is conceived as a final settlement against the payment by Italy of $5 billion spread over 20 years. All the monies pledged were designed for infrastructural projects. No reparation payments were set aside to the benefit of the victims of the Italian warfare in Libya. Now I come to the discarded background, World War II. This background was not mentioned in the judgment of the Constitutional Court. It narrows down the litigious constellation to a purely bilateral relationship between the war victims and Germany. Not a single word is devoted to the fact that the controversial actions filed before Italian courts and tribunals were the last stage of a complex process of settlement of the consequences of World War II. It is true, of course, that Germany unleashed World War II. On the other hand, as is well known for many years, from June 1940 to September 1943, Italy stood at the side of Germany in invading not only other European countries like Albania and Greece, but also territories in the north of the African continent. The damages resulting from these acts of aggression were tremendous. At a late stage in September 1943, Italian leaders eventually took the courage to rupture the links with the German dictator. Fortunately, it's for the good of Italy, and they should have done so much earlier. Much could have been avoided if they never had concluded the alliance with Adolf Hitler. Maybe Adolf Hitler would not have the courage to attack the Soviet Union, but I'm not blaming Italy for on that ground. But of course, in 1945, the question arose how Germany, in particular, had to repair the losses caused by its armed forces, not only armed forces, and similar questions arose with regard to Italy, although obviously to a lesser degree. The primary determinations, and now to me this is very important, were made by the three principal Allied powers, the Soviet Union, the United Kingdom and the United States of America. At Yalta and Potsdam in 1945, they decided that the classical model of interstate responsibility should be followed. Germany was to compensate for the harm caused by it or by her to the greatest possible extent through different modalities, by removals from the industrial capital equipment, by confiscation of its external assets, and also by territorial changes. It was agreed at Potsdam that the territories east of the Oder-Neisse line would provisionally be placed under Soviet and Polish administration, the intention being to allocate those territories definitively to the Soviet Union and to Poland by virtue of a peace treaty to be concluded as soon as possible. Never was there any question of granting specific compensation to individual war victims. These were clear and straightforward determinations, although not formalized in an instrument explicitly called international treaty, which, however, by virtue of its substance, nonetheless constituted such a treaty, the Potsdam Agreement. The three powers purported to act for all of the states that had been at war with Germany. Indeed, a reparation scheme was established with an inter-allied reparation agency based in Paris that was entrusted with distributing the assets taken from Germany among all of those states. No objections were raised. It was generally agreed that the principal victorious powers were entitled to make those determinations, although their actions are hard to reconcile with the general principle of international law that no state can unilaterally impose duties on another state. Yet the situation of 1945 was of a peculiar nature. The three powers had borne the brunt of the war effort against Germany. Therefore, their leading role was recognized not only in political but also in legal terms. It needs no special explanation that, in principle, the settlement of war damages cannot proceed along two different routes. On the one hand, by following the traditional interstate model, on the other hand, by additionally granting individual compensation to every victim. Although Germany has been willing to do so in respect of persons persecuted on racial grounds, treaties have been concluded with Italy in spite of that. And Italy then had to waive on its own behalf and in behalf of all Italian nationals any claims against Germany deriving from occurrences during World War II, Article 77 of the Peace Treaty of 1947. You know that no peace treaty bearing that name has been concluded. It was finally in 1990, at the point of reunification, that finally the four Allied powers concluded together with Germany the treaty on the final settlement with respect to Germany. This treaty, although remaining silent about any measures of reparation, was indeed meant to put a definitive end to the issue of reparations with regard to all states formerly at war with Germany. The great step taken on that occasion by Germany was the recognition that the territories for many years provisionally placed under Polish and Soviet occupation would henceforth be considered as having passed under the full territorial sovereignty of those countries. On the other hand, by accepting the title of final settlement, the Allied forces certified that they also would henceforth be debarred from pursuing any further war claims against Germany. Germany, on the other hand, renounced any possible claims against the Allied powers on account of the breaches of humanitarian law committed by them. The main price paid by Germany for that transition to a stage of permanent and enduring peace was high. The renunciation of a quarter of its national territory was the main element of compensation designed to satisfy all former members of the United Nations that had allied to fight the Axis powers. This is a point probably that will have to be discussed, but it has not been mentioned enough. It should have been. Yes, I know that. I have to speed up. Now, the challenge to the principle of jurisdictional immunity, the essence, finally, of the judgment of the Constitutional Court lies in its challenge to the principle of jurisdictional immunity. The CC took care not to call into question this principle as such, but maintained that its ruling was confined to the operation of jurisdictional immunity within the sphere of Italian jurisdiction. This cautious approach, a sophisticated application of the traditional dogma of dualism, cannot, however, hide the simple truth that the gist of jurisdictional immunity, namely the prohibition for national courts and tribunals to entertain certain suits brought against foreign states in respect of governmental acts, was suspended. Jurisdictional immunity is a device designed to produce its effect precisely within the domestic legal order of a foreign state. If that effect is precluded, the principle is deprived of any substance. It remains within the international legal order as a nudum ius, a hollow name. Is it justified to leave aside such a remnant of the classic system of relations between sovereign states at a time when a deep change is going on from the traditional state-centered order to a new international order whose foundations are human rights? The Constitutional Court held that by rupturing the walls of sovereign statehood, justice would finally attain the prominent position which it deserves in the international legal order. This assumption rests on shaky foundations. The Constitutional Court did not provide sufficient reasons to support its stance. Generally, judgments of a national body remain confined ratione territorii and ratione personae to the area under the jurisdiction of the foreign state concerned. They are unable to make determinations on the rights and duties of another state. Where governmental activities overlap, in particular when the authorities of a specific state carry out activities on the territory of another state, including by engaging in armed hostilities, a hard-to-solve problem arises. Should the territorial sovereignty of the foreign state prevail, knocking down the sovereign exemptions and prerogatives of the external actor? International law has never embraced such a radical solution. It has established rules and principles with a view to disentangling the imbroglio. With only rare exceptions, it has generally respected the foreign authorities acting on foreign soil as the representatives of another state that keep their sovereign status, even when showing conduct not in conformity with the requirements of international law, not forfeiting it on that ground. Accordingly, a regime of occupation has evolved under international humanitarian law. Disputes arising from the presence of two kinds of sovereign power on the same territory are disputes under international law. They must accordingly be solved by mechanisms established pursuant to international law. The attempt to shape solutions unilaterally, making determinations exclusively from the national viewpoint, make little sense. Progressively, a system of mutual recognition of national judgments has arisen in respect of ordinary private law disputes, where the hardcore of national sovereignty is ultimately protected by the concept of ordre public. However, states have never been prepared to submit to decisions of external authorities except with their explicit or implicit consent. Accordingly, foreign judges cannot interfere in the domestic matters of a state. Their judgments have no chance of being heeded whenever they touch upon the key areas of national policies. If after an armed conflict, all of the individual victims should try to assert their alleged reparation claim, the actual capacities of the judicial system concerned would be brought to collapse. And the judgments resulting from such a Herculean effort would be worthless, having no chance of ever being enforced. Encouraging the victims to bring suits against a wrongdoing state may sound eminently constructive and promising. That's the view of the Constitutional Court. In real terms, however, the successful claimants could not gain anything really tangible. They might achieve a moral victory, but little else. Judgments against a foreign state can be enforced only with great difficulties. We know that from experience and from the UN convention, the recent UN convention. Moreover, in such a situation of emergency, the requirement of preserving equality becomes a priority. Not those who have succeeded in hiring the best lawyer should be compensated first, but it should be the task of the victim state to establish aggregated lists of victims and losses, vindicating those injuries vis-à-vis the wrongdoing state. Making pronouncements at random according to fortuitous circumstances must inevitably lead into chaotic disaster. Now, coming back to the case, according to the Constitutional Court, individual claims arising from grave breaches of international law can never be taken away and must be enforceable under all circumstances. That's the essence of the judgment. If this proposition were true, the future of international law would be dark. But the international legal law is not a system whose architecture is framed by judges. Its foundations must be laid down through consistent and patient efforts of negotiation and reconciliation. Heinrich von Kleist's protagonist, Michael Kohlhaas, should not become the leitmotif for rigidity and stubbornness in addressing international confrontations ex post. No peace treaty purporting after an armed conflict to establish a just and stable situation of peace could be concluded if the parties were prevented from extinguishing the great bulk of the controversial claims and counterclaims. There's no need to describe in detail all the crimes committed during World War II on both sides, in particular by Germany. The Soviet Union and Poland suffered tremendously and had to deplore millions of deaths among their populations. And Italy underwent traumatic instances of blind, murderous revenge. But the civilian population in Germany was not spared either. 12 million Germans were driven from their homes, and many millions, women and children, died during their flight. During aerial warfare, civilians were targeted with the explicit aim to burn them to death. German women were deliberately declared a booty for the soldiers of the Soviet Union, and they were indeed raped in frightening numbers. Since prisoners of war and their treatment were at the core of the dispute before the International Court of Justice, there's that famous observation in the judgment, the treatment of German prisoners matters too. Contrary to the rules of the 1929 Convention on the Treatment of Prisoners, the Germans captured by the Allied forces were not released immediately after the end of hostilities. Russia kept German prisoners until 1955, 10 years after the German military surrender on 8 May 1945. The United States and the United Kingdom sent more than 600,000 German prisoners of war from their zones of occupation to France, where they were used as forced laborers. According to credible international reports, they were in high numbers assigned to dangerous demining activities. The last...
Could you come to an end, Professor Tomasza? Okay.
By the Constitutional Court, the German victims of grave breaches of international humanitarian law would also be entitled, in the same vein as the Italians protected by the Constitutional Court, to bring suits against the Allied powers before German courts and tribunals. In the field of human rights, the determinative paradigm is equality. Forfeiture of rights of the nationals of a guilty nation does not exist. However, such individualization of the financial settlement would largely exceed the confines of any notion of reasonable adjudication. Now, concluding observations, I was already summoned to come to an end, and I do indeed come to an end. I think the Constitutional Court has handed down a judgment that has chosen to circumvent all of the grave difficulties that need careful consideration before a targeted assault on one of the foundational elements of the international legal order was launched. Sabino Castelli, in my view, rightly said the case was not ripe for decision. What are the solutions? Short-term consequences. No legal way by judicial procedure is in sight. Germany might return to the ICJ, but that would not resolve the issue of the Constitutional Court's main view, its stubborn attitude. Negotiations are inevitable, in particular, if measures of constraint are taken by the successful applicants. But such negotiations have to require pre-negotiations that determine beforehand the subject matter of the negotiations. Individual compensation makes no sense. Long-term solution, peace negotiations should be started after the war, and we need neutral institutions. In particular, I think an institution which is prepared for the task would be the Peace-Building Commission of the United Nations, or maybe the Security Council, but the Security Council is, as we know, a very difficult institution which does not always follow the way of peace and justice. Thank you.
Thank you, Professor Tomasza. A very interesting and stimulating speech, I would say. We have a lot of food for discussion right now, I think, about that. In the last couple of days, we had 4 panels discussing different issues, or always related to the case we are discussing. I have been here yesterday, only yesterday, but I have told that also the first day, Thursday, was very, very interesting. So now, for this reason, we have 4 rapporteurs that will brief us about what has been discussed on these 4 panels. After that, we will have a break, a coffee break, and then a round table, and the last part of the round table will be open to the intervention from everybody. So the first panel, the rapporteur for the first panel is Dr. Boggero. Dr. Boggero, prego.
Thank you, Mr. Speaker. Well, in the first panel dealt intensively with the question as to whether, and if so, how reparation should be awarded to the victims, even after Sentenza 238 was released. Well, the judgment as such did not make a possible upholding of state immunity conditional upon any compensation scheme. This means that the existence of an alternative effective remedy to individual claims filed with domestic courts, that is to say, for instance, the arrangement of a bilateral compensation scheme by Italy and Germany, does not per se prevent Italian courts to continue denying state immunity, at least until the Italian Constitutional Court will clarify that the existence of an alternative effective remedy satisfies the requirements of Article 24 of the Italian Constitution. And on this point, I think there was quite a broad consensus. Without prejudice to this question, the panelists were of the opinion that as a matter of fact, there is a growing discontent about how different categories of victims were fully excluded from adequate compensation over the decades. There is a reason why there is a need, and there was a broad consensus on that point too, that there is a need to take a clear step forward, moving away from the implications of this judgment and in general of the quarrels of the past. The opening of new negotiations for awarding monetary compensation to the victims would therefore be the most tenable solution for addressing the problem once and for all. The panelists designed the entering into negotiations by Italy and Germany as a duty of moral nature, which, however, can also be framed as positive law. In particular, they drew upon paragraph 104 of the 2012 ICJ judgment, according to which, and I quote, the claims arising from the treatment of the Italian military internees, the IMEs, together with other claims of Italian nationals which have allegedly not been settled, could be the subject of further negotiation involving the 2 states concerned with a view to resolving the issue, unquote. It appears a convincing proposal to read this passage of the court as providing for a soft procedural obligation for Italy and Germany, at least to undertake negotiations, if not even to provide compensation to victims insofar excluded. How can paragraph 104, so to say, be triggered, and how should a possible compensation scheme look like? Well, on this point, opinions in the panel diverged. First of all, either Italy or Germany can unilaterally activate an alternative dispute resolution pursuant to Article 25 of the 1961 Bonn Agreement, a mechanism which has never been used to date and which could be useful to settle the question as to whether Italy and Germany really waived the claims of some victims on grounds of the 2 treaties, the 1947 Peace Treaty and the 1961 Bonn Agreement, without referring the question again to the ICJ. Panelists agreed that a compensation scheme should be construed as a bilateral German-Italian initiative. Also Italy, and in this respect I beg to defer kindly to what Professor Tomusz had said, because there was a broad consensus among at least panelists that also Italy retains a moral responsibility in this respect, since it prevented victims to seek redress for a long time, whereas Italian citizens participated in massacres perpetrated by the Nazis. The joint initiative should be aimed at establishing a joint fund for compensating victims on a lump sum basis, and could engage also NGOs and other private actors. The lump sum payment might be of a symbolic nature and could amount to approximately 2,500, 3,000 euro for each victim. As to the personal scope of the beneficiaries of the bilateral agreement, Italian military internees, other Italian nationals who suffered the loss of their relatives on grounds of massacres between 1943 and 1945, as well as the heirs, they all could be included, even if it was also considered by some participants that the fund should not necessarily afford compensation to the victims' heirs, similarly to what happened with the recent deal reached by Germany and Russia for former Soviet military prisoners. The fund should be supplied equally by the Italian and the German state, but possibly also by private actors and other stakeholders. The solution developed within the first panel goes far beyond setting up a memorial place for military internees in Berlin or establishing a joint cultural foundation, as the German-Italian Commission of Historians recommended back in 2012. And that's the point of the whole panel. Yeah, thanks.
Okay. Dr. Oehler-Schramm, you were the rapporteur for the second panel, right? Please.
Thank you very much. Yes, I return to the aspects treated in the panel number 2. And this panel was dedicated to the concerns from an Italian perspective, presented from a viewpoint of Germany and of Italy with regard to Decision 238 of the Constitutional Court. This topic was much more considered under concrete aspects than panel 2, because as a consequence of the decision of the Constitutional Court, Italian tribunals are now forced to tackle questions of the merits of the cases, bis until then have slept silently under the veil of immunity from jurisdiction. I will come to this in a moment. I would just make some preliminary points, which first will not really be astonishing, namely that the assessment of Decision 238, viewed from an Italian and a German perspective, do not differ really essentially. This was due to the fact that we had two very renowned commentators, namely Professor Heike Krieger and Professor Paolo Palchetti, who assessed the situation from a merely legal viewpoint and therefore demonstrated what is the law in force governing the questions at stake. And so the discussions really focused then on what shall to be done in the future, that perhaps there has to be an development of the international law on state immunity, but that still is a situation in the context of lex ferenda and not part of the lex lata we had to consider. A second point, which was a little bit astonishing, was the fact that there is no Italian view on the situation. There is no uniform position of the Italian state, but the reaction differs between state organs, and that, I will be short on this point, has some impact on the highly important new development of international customary law on state immunity, which was so much pressed by the Italian Supreme Court, the Corte di Cassazione and the Constitutional Court. Because there is no uniform state practice, it may be absolutely difficult to see how then there will be a contribution to the emergence of new international law. That leads me to the more concrete questions, which are namely two. On the one hand, there is the question of immunity from execution. The immunity from jurisdiction only tells us that the court has to decide on the merits of the case, but that does not say anything on the consequences of such decisions. And there was unanimity not only in the International Court of Justice, but also between the commentators and even in the Constitutional Court decision, that immunity from execution still does exist, and this may lead to the not very convenient situation that the victims now may have a judgment, but that finally nothing will change for them. They will be sort of betrayed because decision 238 of the Constitutional Court will not have any practical effect. This would then perhaps lead to some sort of forced execution and then raise the question of the international responsibility of Italy. Because if, and we may suppose, Germany will not comply with the judgments of the Italian courts, then the only possibility to have consequences for the victims would be forced execution. But as nobody really contests that immunity from execution is still a norm of international law, Germany would have the right to require compensation for all damage caused to its property. And that would lead to the very strange conclusion that finally it will be Italy to pay reparation for the victims. I then would like to come to some problems which have been alluded to also in the talk of Professor Tomoschat, namely concerning questions that the Italian courts have to tackle, and that are questions which are very, very intricate and delicate, and which perhaps should not be left to national courts. The first question which will be tackled is the question of who is a victim. Is the family of a victim empowered to claim reparation until what generation? Children, grandchildren, or even more? This question has to be answered by Italian courts, raising the question of the time factor. Are there any limits for bringing claims for acts committed more than 70 years ago? And how should reparation look like? Is symbolic reparation enough, or perhaps satisfaction? These and other fundamental questions, such as prescription, forfeiture, admissibility, and so on, will have to be tackled by the Italian tribunals, and I think that is really a very difficult task. And this the more as they imply more fundamental and more far-reaching questions which need a solution perhaps on a broader basis, and which really are also seen in other situations, not reflecting only the situation between Italy and Germany, but which have been seen also in international jurisdiction, namely the European Court of Human Rights, and they concern the question whether at all individual compensation after wars is the right way to tackle the questions. This issue has severe implications for questions of terminating armed conflicts and restoring peace and friendly relations between former enemies. Will they be ready to conclude peace treaties and to agree on lump sum agreements if individual compensation is imminent? What about the huge number of victims and the time for really settling such claims? This state of affairs then led to the leitmotif which accompanied nearly all the discussions of the last 2 days, and which refer to the obiter dictum of the International Court of Justice in its paragraph 104 concerning negotiations. This seemed to be a very consensual aspect, but there were some difficulties how to tackle it. There is no doubt that good reasons, namely legal reasons, can be induced by Germany to stick to its position and not to renegotiate because the right is on the side of Germany. But perhaps it may be considered whether the shadow of the past, which lies on the otherwise friendly relations between both states and which are in permanent contact, working together in several and numerous international fora, it may be the time that now we come to a solution of this difficulty of the past, so that perhaps it is the time to abandon legal reasons or legal reasoning for the sake of reasonableness. That means that a good will approach could perhaps be made to conclude an agreement, but I must say that such goodwill approach will in any case only have success if both states would be ready to make relevant concessions as compared to their original positions. That was my comment, and I thank you for your attention.
Thank you, and now a brief summary and a convincing solution by Professor Ungarn-Sternberg.
Ladies and gentlemen, the convener has also asked the conference to take a European law perspective. We are dealing, after all, with a conflict between two European countries. This European perspective raises several questions, many of which you can find in the program, but which can be roughly organized along 2 lines. First, is there and should there be a particular European law of state immunity? And second, is there a particular European way of dealing with conflicts which could help to find a short-term solution or which could teach us lessons in the long run? Now, first, is there a particular European law on state immunity, a European Sonderweg, granting an exception from state immunity in specific cases, for example, allowing for remedies for grave breaches of public international law, such as genocide, war crimes, or crimes against humanity? The short answer is no. It was shown that the necessary elements of a corresponding regional customary law cannot be established. State practice in most European states, except for Italy and Greece, does not limit state immunity. Moreover, the principle of full state immunity for the exercise of state authority, acta iure imperii, is confirmed elsewhere. The EU Brussels regulation, which provides that civil and commercial judgments from one EU state are enforceable everywhere in the EU, now expressly states that this enforceability does not extend to a liability incurred by a state for acts and omissions in the exercise of state authority. Besides, European states are very concerned not to lose state immunity for activities of armed forces during an armed conflict, even if they accept the so-called foreign tort exception to state immunity under the UN or the European Convention on State Immunity. This is stated explicitly by the European Convention on State Immunity and made clear by several declarations of European states exceeding the UN Convention. Now, finally, the European way does not only refer to the European Union, but also to Europe in a broader sense, and to the European Council in particular. In this regard, the European Court of Human Rights also deals with issues of state immunity. It has repeatedly held that the right to access to court guaranteed under Article 6 ECHR may be lawfully limited by state immunity, even in the face of torture, accepting the legitimate aim of complying with international law to promote comity and good relations between states through the respect of another state's sovereignty, al-Azani. Now, even if commentators took different positions as to the potential for a further development, it was beyond dispute that there is no European exceptionalism when it comes to the law of state immunity as it currently stands. However, would it be a good idea to have a specific European customary law of state immunity, granting individual access to court in certain circumstances? Again, the brief answer is no. At least that is what the majority of the conference felt. First of all, customary law, which is typical of primitive legal systems, was considered the wrong kind of legal source for the delicate task of reconciling the state immunity on the one hand and the individual's right of access to court in a sophisticated legal order. Moreover, there was general unease with the idea of a European Sonderweg, European exceptionalism, and a European cure for the world. Am europäischen Wesen soll die Welt genesen. But most importantly, restricting state immunity was rejected because a majority of participants feared it would open the Pandora's box. It would endanger any attempt to reach peace and stability after war, as the victims would be encouraged to bring claims in their own countries or elsewhere, instead of living with inevitable injustices. It would incite forum shopping in Europe, and if other states followed, it would put European states at the risk of being exposed to judicial proceedings abroad, which would not necessarily satisfy the European idea of the rule of law. Now, turning to the second question, European solutions and lessons, I would like to start with a preliminary remark. What does Europe, the European Union, as well as the Council of Europe, stand for? The good news is that our debate, standing out against the current trend of Euroscepticism, recalled the success story of Europe, which was implicitly and explicitly characterized by commentators by peace, stability, democracy, rule of law, and human rights. This success story also helps to explain why the position of the Italian and Greek claimants have such an appeal after 70 years, or 70 years after World War II. In present-day Europe, it seems less urgent, happily, luckily, to sacrifice individual justice in order to guarantee peace and stability, and it seems more pressing to provide the highest possible standard of individual rights. Now, does Europe provide for solutions to our conflict at hand? Some stressed that the conflict was so far dealt with in a European way. Disagreements are brought to court, the International Court of Justice in our case, and are not resolved by the use of force. Now, if that appears somewhat minimalistic, one might add another point. The legal debate, and I want to stress that particularly during this morning, the legal debate about the correct position on state immunity or the right to access to court does not run along national lines. Both Italian and German scholars can be found either supporting the International Court of Justice or the Italian Constitutional Court, either the case for state immunity or for individual rights. And this is not at all a matter of course. However, does the European way also provide for more specific solutions or lessons? With regard to short-term solutions of the specific dispute at hand, the answer must once again be no. In our panel also, the participants discussed the arguments in favor of the legal path, further judicial proceedings, and the political path, negotiation, settlement, while not coming up with third magical options. Neither did the panel suppose that there would be any short-term implications for European military operations. If these operations are attributable to the states, the corresponding legal framework of state immunity does not differ from cases of unilateral operations. In practice, the states would regularly enjoy immunity based on status of forces agreements concluded with a territorial state that is based on treaty law, which makes it even harder to restrict immunity since this would have to be based on jus cogens. Now, after giving three answers in the negative, what about the success story of our panel and about a European way of dealing with things? It emerged that the most salient feature of a European way was to offer long-term lessons about dealing with legal conflicts. First, Europe has a long history of judicial conflicts and judicial dialogue. I will only mention some of the most prominent cases. Within the now European Union, constitutional courts have invoked constitutional provisions to, at least potentially, limit the reach of European law, Solange Constellation. Within the framework of the European Convention on Human Rights, the European Court of Human Rights defines the scope of its jurisprudence with respect to EU law, the Bosphorus Constellation. Finally, the European Court of Justice upheld human rights in the face of the anti-terrorist sanctions regime set up by the UN Security Council, the CADI Constellation. And second, European legal orders have a long history of reconciling and balancing legal rights and interests, as the omnipresent principle of proportionality illustrates. Insights from this particularly rich experience can guide courts in future disputes. The panel looked at two techniques of judicial dialogue in particular: the counter-limits doctrine applied by the Italian Constitutional Court in Sentenza 238 vis-à-vis the International Court of Justice, and the test of equivalent protection used by national and European courts in the Solange and Bosphorus cases, for example, to ensure respect for fundamental rights vis-à-vis the European Court of Justice. The counter-limits doctrine prevents international norms from entering into the national system for the purposes of safeguarding the supreme principles of the Italian Constitution. This approach can have positive effects by first confirming the existence of common or at least compatible values in different legal systems, and by second warning the courts of other legal orders about potential conflicts. However, as was frequently repeated during the conference, the problem of the barking dog arises. A dog that only barks but never bites might lose its credibility. And once the dog bites, that is, once the counter-limits doctrine prevents the application of international legal rules, the contrast between legal orders becomes difficult to reconcile. The main idea behind the equivalent protection technique, on the other hand, lies instead in the assumption that safeguarding fundamental rights is a cornerstone of both the international legal order from which a legal act originates and the national legal order that should implement it. Thus, it is accepted that the protection provided at the national or convention level and the EU level does not need to be exactly the same, but may be comparatively adequate or generally acceptable. The two main differences between these techniques are evident. First, the equivalent protection technique entails a presumption, the presumption of equivalent human rights protection, which expresses a particular respect for the international legal order. Second, in assessing the question of equivalent protection, this technique is more flexible and apt to take different legal interests into account, whereas the counter-limits doctrine is hierarchical and rests ultimately on domestic law and on dualist premises. Furthermore, it has to be emphasized that there are big differences between a judicial dialogue taking place between a domestic court and the ICJ on the one hand, and on a dialogue between a highly integrated or within a highly integrated legal order such as the European Union or the European Convention on Human Rights on the other hand. Coming back to the barking dog metaphor, it is much easier to bark, nearly bite, and to correct, undo, or heal a wrong bark or bite, so to speak, if there are many avenues of judicial dialogue, avenues such as the referral procedure under Article 267 of the Treaty of the Functioning of the EU, or the individual application procedure under the convention system. Moreover, the CADI situation, that is the case in which the European Court of Justice upheld European human rights in the face of UN sanctions, is not comparable to the situation of the Italian Sentenza either. It was stressed by all participants speaking on that matter that opposing sanctions by the Security Council, a political organ of 15 states, is something wholly different from questioning the authority of the International Court of Justice, the principal judicial body of the UN and the international legal order. As a consequence, comparing the different techniques supports a critical assessment of Sentenza 238. This critique may be carried further if one looks at the material reasoning regarding the scope of the right of access to justice. Here, some participants preferred the approach taken by the European Court of Human Rights, which confirms that immunity affects the rights to judicial access, but also accepts that immunity might limit this right. Other participants suggested, however, that rule of state immunity is not open to such a form of balancing exercise. As a result, the European approach would not mean, rephrasing Frank Sinatra or even Donald Trump, we do it our way, but it would mean to reflect the diversity of European solutions to reach a better mode of conflict resolution in the future. Thank you.
Thank you very much. And now an international perspective, finally, from beautiful but rainy Scotland, by Filippo Fontanelli.
Here we go. Thank you very much. Our panel was the last one yesterday. It dealt with the perspective from the international law point of view. I will integrate the conclusions of the panel and the outcome of the discussion that followed in this short presentation. I'll try to distill these conclusions in a set of points so you can follow more easily, and I hope it will reflect the degree of consensus that was reached. I apologize, some of that might have been covered already. We should take it as a sign that there was some common ground and shared understanding. I will signal it so you can recall what's been just said. Now, from the point of view of international law, the applicable law is clear, we concluded. If we do not focus on the law as we wish to be, but on the law as it is, we have some common understanding. A state immunity in the civil courts of another state is granted also in the case of serious human rights violation, and irrespective of whether the victims could bring their cases to court otherwise or resort to an alternative remedy. This is what the law is, as we speak. What the law should be is another story that is worth telling, because if certain objectives cannot be achieved through the law, it still would be appropriate to pursue them if we like them very much. Now, because an alternative remedy is not a necessary condition for the granting of immunities, it is not crucial to check whether the Italian victims had been afforded one. This is a point of controversy if you read the Constitutional Court's Sentenza alongside the German government's position. The Italian judges say there wasn't another remedy. The German court said, oh, these victims brought claims in German courts. So it is a point of controversy, but the issue is slightly beyond the point from an international law point of view, because it's not an indispensable condition, and also because, as we heard already, the European Court of Human Rights considered that Italian claimant suits in Germany were conducted in a way that did not violate the Convention's norms on a fair trial. Antje von Unger-Sternberg just told us that. So we can move on. We can decide this is not desirable, but that's what we have. Now, given the overview of what the law is, it is obvious that the Italian Constitutional Court paved the way for Italy to breach the law. Italy breached the law subsequently and must now respond for its responsibility. Now, the academic drama surrounding the decision, however, might be overstated at the expense of the underlying human drama, which unfortunately cannot be overstated. Now, Germany is entitled to invoke responsibility. Germany is the aggrieved state. But the episode does not mark the end of international law or international law's normativity as such. It's an episode of breach. There's no reason it will be repeated or that it will inspire others as such. It could do, but there's no reason to believe it happened necessarily. The circumstances of the cases were narrowly circumscribed to a very idiosyncratic historical and legal scenario, we might accept the idea that the law is a breach as an inevitable occurrence. It happens. Now, Christian Tomuschat warned us of the unfathomable consequences of the Sentenza. We can think of the factual and legal matrix behind the Sentenza and decide that it's very easy to distinguish in future cases and not to repeat the same reasoning. We might think otherwise, but it's true. The consequences are unfathomable, which means they cannot be predicted. So let's not do what we cannot do. Now, given the overview of the framework of responsibility, now the general understanding is that the framework of legal responsibility will not help overcoming the deadlock. A cohort of excellent, well-intentioned, well-fed lawyers try to look into it and concluded that legalities will not foster reconciliation. That was a heartfelt conclusion yesterday. Now, if the applicable law can only help us so much towards peace, legal peace, it is worth taking note that Germany is not required by the law to take steps to explore a way to resolve the issue. Does not mean it should not do so necessarily. In fact, the likelihood that in this case a mere application of the law might yield unfair outcomes recommends exploring voluntary action that transcends what's merely owed by way of obligation. This is true, of course, assuming reconciliation and legal peace are truly valued. If we claim that, we would like to achieve that. Now, reconciliation that does not boil down to real litigation depends on goodwill when it comes to coming together to find solutions that inevitably require sacrificing one's interests for a common purpose. It might be wiser to gloss over the question whether an attempt to negotiate is made out of obligation or out of favor. It's not a sin to do a favor. In the worst case scenario, pretend generosity will be met by pretend gratitude. More likely, actual generosity will be met by actual gratitude. But in either way, something durable can be achieved which transcends the mental reservations. This is negotiation 101. The comparative advantage of honey over vinegar is well researched. In short, fixating over the legal conundrum has a frustrating effect that was understood. Law can be imperfect that way, and in this circumstance has exhausted its potential of resolving the dispute. Arguing legalities ad nauseam, sorry, that was Latin, too much, excessively, can only aggravate this particular dispute. A solution must be found that, while not legally required, is legally tenable, steeped in both parties' goodwill. This is also what the International Court of Justice hinted to when it mentioned negotiation in this famous paragraph 104, whether it indicated an obligation or a soft obligation might open a can of legal worms. There's no such thing as a soft obligation. What is it? And nevertheless, it suggested an adequate course of action. That is a recommendation. That is a suggestion. Why not taking it up? Now, there was a point made between legal reasoning and being reasonable. And that resonates in Italian very well. It's the difference between avere ragione and essere ragionevoli. I don't know whether it translates in German, but it's the difference between being right and being reasonable. And the fight over who's right has exhausted its potentiality. What about the attempt to be reasonable about it? Now, Germany and Italian courts each base their position on principles, but there's a gulf between the writer's views and the reality, which is less honorable. Germany clings to a privilege, is entitled to do so. Italian courts invoke higher fundamental principles, but their actions might lead to nothing if the victims are unable to execute the judgments. The solution of this impasse must go beyond the immediate scenario of Sentenza 238. Germany knows it will not pay at the moment. Italy knows that too, but sent victims to courts anyway, knowing they will end up in this Kafkian cul-de-sac. Without apportioning blame, it clearly appears that the situation is a bit dishonorable because the victims are suffering from it. And we heard about the possibility that they have some redress through execution. We heard from Karin Oehlers-Fram, and it's true, at the moment, there's no suggestion that immunity from execution will be lifted or waived, which means at the moment, the victims might go all the way through and get nothing out of it. This is clearly a lose-lose situation. Now, what could we do? And that's 3 minutes, then we're done. Two things might be mentioned. One, on the sustainability of international law in episodes of disobedience. And one more on the specifics of this dispute. As we said, we observed yesterday that international law will still exist, and we can consider this as an episode. It will pass. Every time there is an episode of disobedience, there's momentaneous disruption. Occasionally, it causes development. Sometimes it doesn't, but it happens. Now, it is, however, true that even when disobedience might be accepted as a possibility, appearances matter. Sharing the reasons for non-compliance might elicit sympathy, and when a breach is perceived as principled, it's more difficult that it be considered a threat to the system. That's why yesterday there was a series of remarks about how the Constitutional Court might have failed to factor in the reasoning, the values of international law, enough to appear principled. It should appear, an episode of disobedience should appear as a suffered, hard decision premised on a sacrifice, a trade-off between values. When that doesn't emerge, then it's perceived as selfish, as self-interested. Now, what about the solution of this impasse? Balancing interests domestically might advise recourse to ways that are different from litigation to afford a remedy to the victims, which is incidentally what can be granted through intergovernmental actions. So here, either state can take the lead, but given the lack of obligations, it would be more appropriate probably for Italy to take the lead, for instance, as Christian Tomuschat suggested, by preparing a list of eligible victims that is precise and that doesn't depend on the pending suits in Italian courts, and show that it is ready, Italy, to set the example of generosity, allocating funds to a compensation scheme, and then inviting Germany to match it, to follow the example, to join in the effort. A fund for compensation, and we've heard Giovanni Boggero discussing some of the possible details, whose funding would be shouldered by both states could be a good solution, accompanied by Italy's commitment to shield Germany from further suits. If that existed, Italian judges could see that the circumstances examined in the Constitutional Court Sentenza no longer applied and could go back to granting immunity. Granted, it might be better if the Constitutional Court clarifies that, but to the extent that the unconstitutionality of Italian law was limited to those cases, a change in circumstances might lead to a change in outcomes, even in the granting of immunity in domestic courts. If negotiations along these lines do not necessarily work, there is the possibility for either party to suggest entrusting a third independent body, a UN commission, to manage the process and to assist in the setting up of a common scheme of compensation. Now, this is roughly the summation of what we concluded, integrated by what we've said today. Now, the limitations of our conclusions reflect the limitations of international law, the limitations of international lawyers. But luckily, there's more to life than law. We trust that Germany and Italy know this well enough, and will set an example, resuming negotiation and the reconciliation path. Thank you very much.
Thank you very much, especially for your concrete suggestions, which were building a bridge back to the starting point of Christian Tomuschat. And now we have a coffee break. Thank you very much.